Okay, media. Sorry, sir.
Yes, appearance. You can go ahead, sit down. You can announce your appearance while sitting. You have muted yourself. Unmute yourself to announce appearance.
My Lord, profound respect, my Lord. Adetayo Talabi
Yes.
for the defendant respondent.
Any other appearance? Any other appearance? It appears the claimants are not represented. This matter is for ruling. The ruling is ready. It will be read out virtually. This is the ruling of the court. This deals with motion on notice dated the 2nd day of February 2022 and filed on the same date. The motion on notice was brought pursuant to Order 17 Rule 1 and Order 64 Rule 8 of the National Industrial Code Civil Procedure Rules 2017 and under the inherent jurisdiction of the court. The application is praying for one, an order of this honorable court stay is proceeding in suit number NICN/UY/41/2018 between Godwin Indem and 45 others versus Mobile Producing Nigeria Unlimited, pending the hearing and determination of the claimant's applicant's motion on notice, seeking leave to appeal, file at the Court of Appeal. In the alternative, an order of this honorable court stay is proceeding in suit number NICN/UY/41/2018 between Godwin Indem and 45 others versus Mobile Producing Nigeria Unlimited, pending the hearing and determination of the claimant's applicant's appeal against the ruling of this honorable court delivered on the 8th day of October 2021, and for further other orders as this honorable court may deem fit to make in the circumstances. The grounds for this application are as contained on the face of the motion paper as follows. A, the honorable court on the 8th day of October 2021 delivered ruling in favor of the defendant respondent and against the claimant's applicants. B, the NICN/UY 41/21 between Godwin Indem and 45 others, Mobile Producing Nigeria Unlimited, pending the hearing and termination of the claimant's applicants. The claimant's applicants have raised substantial issues of law in their grounds of appeal, which shall be determined by the Court of Appeal. D, it is in the interest of justice an order for stay to be granted in favor of the claimant's applicant, as failure to grant same may render the decision of the Court of Appeal nugatory. E, the dependent respondent will not be prejudiced by the grant of this application. The application is supported by a 12 paragraphs affidavit sworn to by the first claimant first claimant applicant. The gist of the facts are that on the 8th of October 2021, this court delivered ruling against the claimant applicant. Being dissatisfied with the ruling, the claimant applicants have filed motion on notice at the Court of Appeal seeking the leave of Court of Appeal to appeal against the decision of the court delivered on the 8th of October 2021. This application for stay of proceeding was brought for the purpose of preserving the subject matter of this suit pending the just and effectual determination of the appeal. The dependent applicant will not be prejudiced by the grant of this application. It is in the interest of justice to grant this application. A written address was filed along with the motion on notice wherein a single issue was formulated for determination to it, whether considering the facts and circumstances of this case, the claimant applicant are entitled to the reliefs as embodied on the face of the motion paper. OK Salau Esquire counsel for the claimant's applicant in arguing the sole issue submitted that the right of appeal is one of the constitutionally guaranteed right, and parties to any suit have unfettered right to appeal against any decision of a trial court that they are dissatisfied with. Counsel relied on Section 243, subsection 3 of the 1999 Constitution as amended to support this contention. Counsel also relied on the case of PDP versus Saro and others reported in 2012 LPLR 14287 Court of Appeal. She also relied on the case of Savannah Bank Nigeria Limited versus Agilo. The citation has been supplied. It is the submission of counsel that stay of proceeding is sought for when an appellant appeal against an interlocutory ruling. The rationale behind this is to preserve the subject matter of the suit being appealed against pending the determination of the appeal. To support this view, counsel relied on the case of House of Assembly of Rivers State and another versus Asobari and others, reported in 2013 LPLR 22845 Court of Appeal. Counsel submitted that in view of the fact deposed in paragraph 5, 6, and 7 of the affidavit in support of the motion on notice, the claimant applicants have shown and demonstrated that a ruling was delivered by this court, which the claimant applicants are dissatisfied with and intend to appeal against them. Hence, this application. Counsel further submitted that the position of the law is that an applicant seeking an order for stay of proceeding must show special or exceptional circumstances, clearly tilting the balance of justice in his favor. In support of this submission, counsel relied on the case of Eze versus Okolonji and the case of Michael and others versus Access Investment Nigeria Limited and others. According to counsel, the claimants applicants have from the depositions contained in the affidavit in support have fulfilled special or exceptional requirement as to warrant to the grant of the order of stay of proceeding. Counsel submitted that based on the authorities referred to in this court, this court should exercise its discretionary power in favor of the claimant applicant. In support of this, counsel supported his submission by the case of Jegede versus Poroye and others. It is also the submission of counsel that the ruling of this court can alter the nature of the claimant's respondent claim if stay is not granted, a situation of complete helplessness will be posted and there may be no possibility of return back to status quo. It is submitted that the claimant applicants have placed cogent, sufficient, and credible evidence before the court to warrant grant of an order of stay of proceeding as the proposed notice of appeal and affidavit in support of the application clearly shows that the grounds of appeal contained therein are competent and arguable on the merit. In addition, the dependent respondent will not be prejudiced in the event that this court grants the stay of further proceeding. In concluding his submission, counsel asked the court argued that the claimant's applicant have demonstrated as well as satisfied the condition for grant of this application. Counsel asked the court to grant the application in the interest of justice. In reaction to the motion on notice, the dependent respondent filed an 11 paragraphs counter affidavit sworn to by one Adetawi Talabi, a legal practitioner in the law firm of Messrs. Banwo and Igodalo, counsel for the dependent respondent. In the counter affidavit, it was deposed that this court on the 8th of October 2021 delivered ruling wherein it was held that the monetary claims of the claimants are caught by doctrine of res judicata and that the monetary claims constitute abuse of court process. The grounds of appeal do not disclose serious issues of law that are recondite, arguable, or substantial. It is also default that it is neither imperative nor is it necessary for this court to grant stay of proceeding as there is no pending as there is no pending appeal before the Court of Appeal, the application is a waste of precious time of the court to delay the trial of this suit. In the written address filed along with the counter affidavit, a single issue was formulated for resolution, to wit, whether the applicants are entitled to a grant of relief sought in the motion. Abimbola Akere Dolu, senior advocate of Nigeria, counsel for the defendant respondent, argued the sole issue under 3 subheadings as follows. 1. Discretionary power of the court. It is the contention of the learned state that an application for stay of proceeding is not granted as a matter of course, but rather as a supplication by a party for exercise of court discretionary power, and grant only in deserving cases based on the peculiar facts and circumstances of each case. To support this submission, the learned state relied on the case of Nika Fishing Company Limited versus Labina Corporation. It is also the submission of the senior counsel that the grant of an order for stay of proceeding is an equitable remedy which is a discretionary power within the discretionary power of the court, the discretion of which must be exercised judicially and judiciously, taking all relevant circumstances into account. To buttress the point being made, reliance was placed on the case of Madubueke versus Madubueke on the principles for grant of order for stay of proceeding. Reference was made to the cases of Maigari Dingati, versus INEC, and that of Akilu versus Payome, as well as United Spiners Limited versus Chartered Bank Limited. It is a submission of counsel that from the implication of the principles of law espoused in the above cited cases, the implication of the principles of law espoused in the above cases is that an application for stay of proceeding has an applicant for stay of proceeding has a duty in law to demonstrate to the court that there are good, cogent, compelling, and compelling reasons for grant of the application. It is the submissions of counsel that in the present application, the applicant has not shown that there exists any convincing and compelling reasons for the grant of the application for stay of proceeding. Counsel asks the court to refuse the application. The second sub-issue argued is existence of valid appeal. According to the senior counsel, the claimant's applicant have not filed notice of appeal, but only filed an application seeking for leave to appeal, which stands a great chance of being refused. In the event it has been held that the mere filing of an application for leave to appeal cannot sustain a grant of relief for stay of proceedings, the power of a court to make an order for stay is in a case is limited to situation where valid appeal has been lodged at the Court of Appeal against the decision of a court whose proceeding is sought to be stayed. There must be valid appeal in court before an application for stay of proceeding pending determination of an appeal can be considered. To support this contention, reliance was placed on the case of Ogunsede versus Societe Generale Bank Limited, where it was held that an application for stay of proceeding will not be entertained unless an appeal has been lodged. In other words, the jurisdiction to stay proceedings of a court can only be exercised where a valid appeal is pending at the Court of Appeal. It is submitted that in the case of Mobil Oil Nigeria Limited versus Kenya Energy International, the Court of Appeal held that where there is an application seeking for leave to appeal pending before an appellate court, the lower court cannot grant an application for stay of proceeding. Counsel also relied on the cases of Ojo versus INEC and that of Eze versus Okolonji. It is submitted that in the absence of a valid notice of appeal showing prima facie case, It is submitted that in the absence of valid notice of appeal showing prima facie good grounds of appeal that are equable with and with a probable chance of success, an application for stay ought to fail, as to grant the order for stay in such a circumstance would be tantamount to the court exercising a discretion in vacuo or without any just cause, without any just or legal foundation. Counsel submitted that the court of law does not act in vain. Counsel asked the court to refuse the application for stay. It is also submitted that it is incumbent on an applicant for stay of proceeding to show from supporting affidavit that the grant of an order for stay of proceedings will serve the interests of justice and that a refusal of same will work injustice to the applicant. In support of this contention, reliance was placed on the case of Nika Fishing Company Limited versus Labina Corporation Sufra. According to counsel, in this case, the applicants have not satisfactorily demonstrated that the grant of an order for stay of proceeding will serve the interests of justice in this case, and has also failed to show that the refusal of the application will occasion any hardship. It is also submitted that the application for leave is a grant designed by the applicants to waste precious time and frustrate the expeditious hearing and determination of the substantive suit pending before the Honorable Court. The third sub-issue is non-compliance with Order 64, Rule 14 of the National Industrial Code Civil Procedure Rules 2017. It is a submission of the learned state that the applicant have failed to comply with the mandatory provisions of Order 64, Rule 14, Sub-Rule 1 of the National Industrial Code Civil Procedure Rules, as applicant have neither exhibited any evidence to demonstrate that an appeal has been entered in line with the Court of Appeal Rules 2021, nor show that they have been granted leave in respect of an application for leave by the Court of Appeal. It is noteworthy that by Order 4, Rule 10 of the Court of Appeal Rules, an appeal is entered in the Court of Appeal when the record of appeal has been received in the registry of the Court of Appeal. In support of these submissions, reliance was placed on the case of Audu versus Attorney General of the Federation and another, where it was held that an appeal is deemed to have been entered when the registrar of the court from which the appeal emanates has forwarded to the registrar of the appellate court a complete record of appeal filed by the appellant in the registry. The transmission of the record to the registrar of the court of appeal connotes entry of appeal. It is submitted that the rules of court are not meant for show and must be obeyed unless waived by the court. And in the circumstances of this case, there has been no waiver by the court. Indeed, in Gateway Holding Limited versus Sam and T Limited, it was held that where there is non-compliance with the rules of court, the court should not remain passive and helpless. There must be sanction, otherwise the purpose of enacting the rules will be defeated. Counsel also relied on the case of Unze versus Federal Republic of Nigeria on this submission. Counsel maintained that the provisions of Order 64 Rule 1 are mandatory and leave no room for discretion due to the use of the word shall. To support this submission, counsel relied on the case of National Assembly versus CCI Company Limited. In concluding argument, the learners asked the court to hold that the applicants have failed to prove their entitlement to the grant of the motion and asked the court to dismiss them with court. Or reply, the claimant's applicant filed a reply on point of law. In the reply on point of law, it was submitted that the claimant's applicant had failed to meet the condition. It was submitted that The submissions of the defendant applicant that the claimants have failed to meet the conditions having a valid pending appeal is an erroneous submission. Submitted that the case relied is only an authority for what it decides. For a case to qualify for an authority, it must have the same similar facts with the case at hand. In support of this contention, reliance was placed on the case of PDP versus ANEC. PDP versus ANEC and that of Okapo versus NIFE. It is the submissions of counsel that it is submitted that on the submissions of valid pending appeal was the submissions on non-valid appeal was erroneous, having been made without due recourse to the applicable laws on the subject. Counsel refers to section 243, subsection 3 of the Constitution as amended and submitted that the section is authority, which denotes a right of appeal, a result of decisions of the National Industrial Court of Nigeria, howbeit with the leave of court. According to counsel, the right cannot be withheld, we cannot be whittled down or inhibited by any statute. To support this contention, reliance was placed on section 1, subsection 3 of the Constitution on the supremacy of the Constitution. Counsel submitted that the contention of the defendant respondent is laid to rest by the provisions of section 30 of the Court of Appeal Act, which clearly provides that an appeal includes an application for leave to appeal. Counsel contended that this is in tandem with the provisions of section 243, subsection 3 of the Constitution as amended, which granted right of appeal to the applicant. It is also the submission of counsel that in view of the provisions of the Constitution and the Court of Appeal Act, the cases cited and relied upon by the defendant respondent was the submission that there must be in existence an appeal before an application for stay can be considered fell into insignificance and must accordingly be discountenanced. On the provisions of section 64, rule 14 of the National Industrial Court rules, counsel submitted that the interpretation given to the said provisions of the rules totally betrays their understanding, lack of understanding of it, of the true import of the essence of the said rules. According to counsel, with the advent of Skybank versus EU's case, every decision of the court is appealable with the leave of court. Counsel continued his submission that the provisions of Order 64 Rule 14 will no longer apply to defeat an application for stay of proceedings made by a party who can only exercise the right of appeal with leave of Court of Appeal on the ground that such an application does not satisfy the requirement embodied therein, i.e. exhibition of a notice of appeal and proof of transmission of record. According to counsel, such an application exhibits the application for leave file at the Court of Appeal. Counsel also submitted the rules of court are simply to guide the practice and procedure in the court in which they apply, placed side by side with the statutory provisions. Rules of court must give way to statutory provision in case of conflict. In support of this contention, counsel relied on the case of Revenue Mobilization and Allocation and Fiscal Commission versus Onwuekpe. In concluding his submission, counsel asked the court to discountenance the defendant respondent submission and be persuaded by the argument of the claimant applicant and grant the relief being sought before the court. Court decision. I have carefully considered the motion on notice filed by the claimant's applicant praying the court for grant of stay of further proceeding pending the hearing and determination of the appeal against the ruling of this court delivered on the 8th day of October 2021. The facts that led to filing of this would have been stated above, and there is no need to repeat them. What needs to be considered is whether, having regard to the facts disclosed by the affidavit evidence before the court, the applicant's application for stay of further proceedings of this court in this case is meritorious. The grant or refusal of stay of proceeding is an exercise of discretionary power of the court which, like all other discretionary power of the court, must be exercised judicially and judiciously, taking into consideration the peculiar circumstances of the case under consideration and the relevant factors. Thus, why an application for stay of proceeding, the court may require the applicant to satisfy the court that the application deserves a sympathetic consideration of the court, because an application for stay of proceeding is an antithesis to the speedy hearing of the pending matter. It must therefore be shown that there is a compelling reason for the grant of the application. The applicant must also show that there is a pending appeal, otherwise there will be nothing to stay hearing in the trial court, and the appeal must be valid and not frivolous. However, it must be noted that an appeal does not operate as a stay of proceeding. That's why any party appealing against interlocutory decision of a court is under a duty to apply for stay of proceeding pending appeal if he believes the result of his appeal will affect the further proceeding in the matter. See the case of JC Limited versus Ezenwa. Due to its interruptive nature to the conduct of the case before the court, stay of proceeding should not be lightly granted unless proceeding beyond all reasonable doubt ought to not to be allowed to continue. See the case of Okeke versus Yoroso. See also Obi versus Elonwoke. The aim of an order of stay is usually to protect the rest, to avoid the situation where the rest is wrecked before the appellate court exercises its jurisdiction. A stay of proceeding is not granted as a matter of routine. It is a matter of law and fact. The law must provide for it, and the applicant must satisfy the court that the proceeding must not be allowed to continue in the interest of justice. See Dingyadi versus INEC, Sufra. See also Onogen versus Federal Republic of Nigeria. This court has indubitable discretion and power to grant stay of proceeding in any cause or matter where there are enough material placed before the court and the court is satisfied that they constitute special and exceptional circumstances. Discretion also involves an examination or consideration of collateral circumstances, so it will be granted where justice of the matter demands in order to prevent the destruction of the race and subject matter of the action and to prevent the hoisting of state of helplessness. It will also be granted to prevent emasculation of the constitutional right of appeal of the applicant, where it is obvious to the court that there are enough strong materials placed before it by affidavit evidence. Therefore, this court will not hesitate to grant order of sort in order to do justice to the parties, pending when their rights will be determined. It is, however, not granted as a matter of course. See Onogen versus FRN Sufra. From a careful perusal of the facts disclosed by the affidavit evidence and argument canvass, it seems to me that the claimant's applicants relied heavily on the application seeking for leave to appeal against the decision of this court to the Court of Appeal to convince the court to grant the order for stay of proceeding, which is being sought before the court. It must be pointed out here that all courts of record have inherent power to grant an application for stay of proceeding in deserving circumstances and situations. That's why this court, as a court of trial, has inherent power to stay its own proceeding where the applicant establishes entitlement to exercise of the discretionary power of the court in his favor. So too, an appellate court. Obviously, the only court which will not stay its own proceeding is the Supreme Court, where a trial court refuses application for stay of proceeding. Similar application could be made to the Court of Appeal. However, it has been established by case law that a trial judge has no power to grant an application for stay of proceeding where an application for leave to appeal is pending before the Court of Appeal. Similarly, the Court of Appeal has no power to grant an application for stay of proceeding where an application for leave to appeal is pending in the Supreme Court. In either situation, such power inures when the appellate court so order. A trial court has no power to hear an application for stay of proceeding where an appeal against a refusal of stay of proceeding has been entered in the Court of Appeal. See the case of Eze versus Okolonji Supra. Applying the principle of law enunciated by the Court of Appeal in the case of Eze versus Okolonji and followed in the other and followed in subsequent decisions of the Court of Appeal, this court does not have the bias to consider and grant the applicant's application. Claimant's applicant's application for stay of further proceeding before this court. The reason being that there is before the Court of Appeal an application in Exhibit A by the claimant applicant seeking for leave of the Court of Appeal to appeal against the ruling of this court delivered on the 8th of October 2021. With the pendency of the application for leave to appeal at the Court of Appeal, this court does not have the requisite jurisdiction to hear and determine the claimant's applicant's application for grant of stay of proceeding. With the above finding, the life of this application has come to an end. In the circumstances, the claimant applicant application for stay of further proceedings of this court must fail, and same has to be struck out for being incompetent. Accordingly, I hereby struck out the motion on notice for stay of proceeding as being incompetently before the court. I make no order as to court parties to bear their respective costs. That is the ruling of the court. Counsel, you have muted yourself.
We are most grateful, my Lord, for the well-considered ruling, my Lord.
You are welcome. Registrar, call the next case. Registrar, call the next case. You have muted yourself. Unmute yourself.
My Lord.
Yes.
Date for hearing.
Okay.
Yes, my Lord.
When do we have dates? Check your diary.
Yes, my Lord. My Lord, the date is open for December 13th of December.
This case is adjourned to 13th of December 2022 for hearing.
As the court pleases.
Hearing notice to be issued and served on the claimants.
As the court pleases.
Call the next case.
Suit number NICN UY 11-2019 between Okon Sunday. 2. Ekpo Umoren Anthony. 3. Ukpong Ezekiel. 4. Okon Dan. 5. Akpadia Thompson. 6. Natali Peter. 7. Nkerowem Akpe and 20 others. And Mobile Producing Nigeria Unlimited. My Lord, the 7th claimant on record is present. Is here.
7th claimant.
Yes, my Lord, on record. Nkerowem Akpe. Others are absent. The defendant is absent, my Lord.
Appearance. Appearance.
With reference respect, my Lord. Adetayo Talabi, my appearance for the defendant.
Mr. Nkerewe, why is your counsel not in court?
I don't know.
Okay. This matter is for ruling. The ruling is ready and it will be read virtually. This deal with motion on notice dated 2nd day of February 2022 and filed on the same day. The motion on notice was brought pursuant to Order 17 Rule 1 on Order 64 Rule 8 of the National Industrial Court Civil Procedure Rules 2017 and under the inherent jurisdiction of the court. The application is framed for an order of this honorable court staying its proceeding in the suit NICN/UY/11/2019 between Okon Sunday and 26 others versus Mobile Producing Nigeria Unlimited, pending the hearing and determination of the claimant's motion or notice seeking leave to appeal filed at the Court of Appeal. In the alternative, an order of this honorable court staying its proceeding in suit number NICN/UY/11/2019 between Okon Sunday and 26 others versus Mobile Producing Nigeria Unlimited, pending the hearing and determination of the appeal against the ruling of this honorable court delivered on 8th day of October 2021, and for such further or other orders as the court may deem fit to make in the circumstances. The grounds for these applications have been as contained on the face of the motion paper and have been reproduced in the body of the ruling. So I will skip reading them. I will also skip reading the submissions of counsel and the summary of the facts. The claimants, applicants formulated a single issue, whether considering the facts and circumstances of this case, the claimant applicant are entitled to the relief as embodied on the face of the motion paper. I have captured the argument of Mr. OK Salau, Esquire counsel representing the claimants. It has been captured in the body of the ruling. I have also, the defendant also formulated a single issue for determination. I have also captured the submissions of learned Sikh appearing for the dependent applicant and the reply. I will go straight to the decision of the court. So when counsel collect the hard copies, they will have opportunity of going through the submissions as captured in the body of the ruling. I have carefully considered the motion on notice filed by the claimant applicants, frame the court for grant of stay of further proceeding pending hearing and determination of an appeal against the decision of this court rendered on the 8th of October 2021. The facts that led to the filing of this application have been stated above and need not to be restated here. What needs to be considered is whether the claimants applicants are entitled to the grant of the order being sought before the court. The court's consideration of whether or not to stay proceeding following an appeal against an interlocutory order depend on a number of factors, one of which is whether the interlocutory order finally disposes of the case. Where an interlocutory order does not finally disposes of the case, as in this case, it would be wrong to stay proceeding because of an appeal lodged against it by an aggrieved party. However, a court should order a stay of proceeding only where an interlocutory appeal, if successful, will dispose of the entire proceeding. If the complaint of the applicant in the interlocutory appeal can conveniently be taken together in an appeal against the final judgment of the court, in the event that the case is determined in favor of the respondent, an application should be refused. See the case Arroyo Joe versus UBA Limited. See also Obi Ruku versus Alice. Also, where the grant of an application for stay of proceeding will unnecessarily protract the judicial process and therefore waste a valuable litigation time, the court will refuse such an application. In an application for stay of proceedings, the burden is on the applicant to show that the proceeding must be stayed pending the determination of the appeal. The applicant can only discharge the burden by placing before the court all relevant materials by way of facts or law or both. An application which is bereft of relevant facts, relevant materials will be rejected by the court. To put it differently, an applicant an action should not be stayed unless the applicant has established beyond doubt that the action ought not to go on. As such, an application for stay of proceeding cannot be granted as a mere respite to the applicant, but only on a very well-founded grounds. That's why courts are enjoined to exercise their jurisdiction most sparingly. It is right law that the power of court to grant stay of proceeding is discretionary. In the exercise of the discretionary power, the court is enjoined to act both judicially and judicially. For the court to grant the equitable remedy, the onus therefore lies squarely on the applicant to establish to the satisfaction of the court that they merit the order being sought from the court. That's why an appeal does not operate as a stay of proceeding. See the case of Kigo Nigeria Limited versus Hormone Brothers Nigeria Limited and another. See also PDP versus Abubakar, where the Court of Appeal Abuja Division Far Adeke, as he then was, has this to say: the exercise of discretion is to grant a stay of proceeding will be prompted by the peculiar circumstances of each case, in which all factors for and against the grant of stay of proceeding must be carefully and meticulously weighed. The claimants applicant have, in their affidavit, relied on the application filed at the Court of Appeal, praying for leave to appeal against the decision and the proposed notice of appeal attached to it. This court, like all other court of record, has the inherent power to grant power of stay in appropriate cases where the applicant establishes entitlement to the exercise of the discretionary power of the court in his favor. However, it has been established by case law that a trial judge has no power to grant an application for stay of proceeding when an application for leave to appeal is pending in the Court of Appeal. Similarly, the Court of Appeal has no power to grant stay of proceeding where an application for leave is pending at the Supreme Court. In either situation, such power inures when the appellate court so orders. This is the case of Eze versus Okolonji. Applying the principle of law initiated by the Court of Appeal in the case of Eze versus Okolonji, which was followed in the subsequent cases of Mobil Oil Nigeria versus Ken Energy International and that of Ojo versus INEC. It will be this court does not have the bias to consider and grant the claimant's applicant's application for stay of proceeding, because for the simple reason that there is before the Court of Appeal in an application in Exhibit A by the claimant applicant seeking for leave of the Court of Appeal to appeal against the ruling of this court delivered on the 8th day of October 2021. With the pendency of the application for leave at the Court of Appeal, this court does not have the requisite jurisdiction to hear and determine the claimant's applicant's application for seeking for stay of further proceedings of this court. With the above founded, this application has become odious and in the circumstances cannot be granted by the court. Therefore, this application must be struck out for being incompetent. Accordingly, I hereby struck out the motion on notice for stay of proceedings. I make no order as to court. Ruling entered accordingly.
He meets us again.
We are most grateful, my Lord.
You are welcome. John, may we give the same date?
Yes, my Lord, it's the same date, same 13th of December.
Is your order?
Yes, the admin, they want to control it.
So you'll be checking in. You'll be checking in.
This case is hereby adjourned to 13th day of December 2022 for hearing. Hearing notices to be issued and served on the claimants.
As the court pleases.
What's the next case?
Suit number NICN UY 06-2019 between 1. Enyediong Ekpo, 2. Ime Okon, 3. Basi Ibok, 4. Samuel Obot, 5. Diakweri Alabala, 6. Sunday Asindi, 7. Bot Efion, 8. Abendego Akpan, 9. Uko Abasiekong Nkanta, and 91 others, and Mobile Producing Nigeria Unlimited. My Lord, the parties are all absent.
With profound respect, my Lord. My name is
Yes.
Adetayo Otalabi. My appearance for the defendants.
This matter is for ruling. The ruling is ready. This is the ruling of the court. This deal with motion on notice dated 22nd day of February 2022 and filed on the same date. The application was brought pursuant to Order 17 Rule 1, Order 64 Rule 8 of the National Industrial Code Civil Procedure Rules 2017 and under the inherent jurisdiction of the court. The application is seeking for an order staying further proceeding of this court pending the hearing and determination of motion on notice before the Court of Appeal, or in the alternative, stay of further proceeding pending the determination, hearing and determination of an appeal against the ruling of this honorable court, and for such further other orders as this honorable court may deem fit to make in circumstances. The grounds for the application have been reproduced in the body of the ruling. I shall skip. The claimants also have filed 12 paragraphs affidavit to support the application, and a written address was also filed along with the motion on notice, wherein is a single issue was formulated for resolution. OK Salau argued the application, and in the written submission, I have reproduced the written submissions of counsel in the body of the ruling. The dependent on their part also formulated a single issue. Apart from filing the counter affidavit, they filed a counter affidavit and followed it by a written address wherein a single issue was formulated. Bimbola Akeredolu, Senior Advocate of Nigeria, argued the application. I have captured the summary of the argument of counsel in the body of the ruling, and a reply on point of law was also filed by the claimant's applicants. I have also captured the reply in the body of the ruling, so I will go straight to the decision of the court. I have carefully considered the motion on notice filed by the claimant applicant frame for the grant of stay of further proceeding pending hearing and determination of motion or appeal filed before the Court of Appeal against the ruling of this court. The facts that led to the filing of this have been reproduced in the earlier on in the body of this judgment or this ruling. I shall not bother to reproduce the facts again. I need to point out here that an order for stay of proceeding either before a court or tribunal or an arbitrator or judicial commission of inquiry is a fundamental interruption in the proceedings of the court or tribunal. Order of stay of proceeding is an equitable order, so it cannot be made in vacuum. The aim of an order of stay is usually to protect the rest and avoid a situation where the rest is wrecked before the appellate court exercises its jurisdiction. A stay of proceeding is not granted as a matter of course routine. It is a matter of law and fact. The law must provide for it, and the applicant must satisfy the court that the proceeding must not be allowed to continue in the interest of justice. See the case of Dingyadi versus INEC and Onogen versus FRN. This court there is no doubt that this court has immense discretion and power to grant the proceeding, to grant stay of proceeding in any course of matter where there are enough materials placed before the court and the court is satisfied that they constitute special and exceptional circumstances. The discretion also involves an examination or consideration of collateral circumstances, so it will be granted where justice of the matter demand in order to prevent the destruction of the rest and subject matter of the action and to prevent the hoisting of state of helplessness. It will also be granted to prevent emasculation of the constitutional right of the applicant where it is obvious to the court that there are enough strong materials placed before it by the affidavit evidence. Therefore, this court will not hesitate to grant order sought in order to do justice to the parties, pending when their rights will be determined. It is, however, not granted as a matter of course. See Onogen versus FRN. I, however, wish to emphasize that a decision whether or not to grant stay of proceeding is the exercise of discretionary power of the court, which must be exercised judicially and judiciously based on the available materials before the court. See in Adwa and that of Ungora versus Wabuze and that and Ajuo versus SPDCN Limited. Therefore, a decision to grant or refuse an application for stay of proceeding is dependent on the facts of each case. That's why the court will not be bound by an earlier authority so as not to better the exercise of its discretion. From a careful perusal of the facts disclosed by the affidavit evidence, an argument can pass. It seems to me that the claimant applicant rely heavily on the application seeking for leave to appeal filed before the Court of Appeal to convince the court of their entitlement to the order of stay of proceedings. It must be pointed out here that all courts of record have inherent powers to grant an application for stay of proceeding in deserving circumstances and situations. That's why this court, as a court of trial, has inherent power to stay its own proceeding where the applicant establishes entitlement to exercise of discretionary power of the court in his favor. So too the appellate court can obviously the only court which will not stay its own proceeding is the Supreme Court. However, it has been established by a case law that a trial court has no power to grant an application for stay where an application for leave to appeal is pending in the Court of Appeal. Similarly, the Court of Appeal has no power to grant an application for stay where an application for leave to appeal is pending in the Supreme Court. See the case of Eze versus Okolonji. Applying the principle of law enunciated in Eze versus Okolonji and other subsequent cases that followed after the decision of Eze, this court does not have the bias to consider the claimant's applicant's application for stay proceeding pending before the court, that pending determination of appeal. The reason being that there is before the Court of Appeal an application in Exhibit A by the claimants applicants seeking for leave of court to appeal to Court of Appeal against the decision of this court. With the pendency of the application for leave to appeal against the decision of this court does not have the requisite jurisdiction to hear and determine the claimant's applicant's application for grant of stay of proceeding. With the above finding, the life accordingly, I hereby struck out the motion on notice for stay of proceeding for being incompetent.
As the court pleases.
I make no order as to court.
As the court pleases. My lord, the same day.
We must go through, my lord.
Okay. This case is hereby adjourned to 13th day of October, 13th day of December 2022 for hearing. Hearing notices to be issued and served on the claimants.
As the court pleases. Suit
Suit
number ICN UY 10 2019 between Okon Johnson and Mobile Producing Nigeria Unlimited. My lord, the parties are absent.
Appearance.
Almost respect, my lord. Adetayo Talabi for the defendants.
Yes. This matter is for ruling. The ruling will be delivered. It's ready.
Yeah.
By the motion on notice dated 20th day of March 2022 and filed on 14th, brought first one to order 64 rule 8 of the National Industrial Code Civil Procedure Rules 2017, and under the inherent jurisdiction of the court, the claimant is praying for an order of this honorable staying proceeding in suit number NICN UY/10 2019 between Okon Johnson versus Mobile Producing Nigeria Limited, delivered on 8th of October 2021, pending hearing and determination of the appeal filed by the claimant applicant at the Court of Appeal. The grounds for the application have been reproduced in the body of the ruling. The application is also supported by 11 paragraphs affidavit sworn to by the applicant himself. I have also stated the summary of the facts in the body of the ruling. A written address was also filed along with the motion on notice, wherein a sole issue was for resolution was formulated by the claimant. OK Salau Esquire Counsel for the claimant argued the said application and the single issue formulated. I have captured the argument of counsel in the body of the ruling. In the dependent in response, file a counter affidavit, file an 11 paragraphs counter affidavit sworn to by one Olua Mayoku David, a legal practitioner in Messrs. Bango and Igodalo, counsel for the defendant. In the written address filed along with the counter affidavit, a single issue was formulated. In arguing the application, the learned Sikh relied on the deposition and also adopted the written address as his argument. I have captured the argument and the summary of the facts deposed in the counter affidavit. I have captured all of them in the body of the ruling, so I will skip reading them. The counsel for the claimant also filed a reply on point of law. I have also captured the argument of counsel in the body of the ruling. So I will now go straight to the ruling. I have carefully considered the motion on notice filed by the claimant applicant praying for stay of proceedings of this court pending the hearing of appeal before the Court of Appeal. The facts that led to the filing of the application have been stated above. In the I'm sorry, counsel, guys. I'm trying. Sorry, I opened a wrong. Yes, I have carefully considered the motion on notice, the affidavit in support, and the counter affidavit, as well as the submissions of counsel. In considering whether or not an application for stay of execution or proceeding would be granted or refused, this is entirely an exercise of judicial discretion, the discretion which must be exercised judicially and judiciously and depend on the peculiar facts of each case presented before the court and the demand of justice. It must be pointed out here that all courts of records have inherent jurisdiction to grant application for stay of proceedings in deserving circumstances and situations. This court also, as court of trial, has inherent power to stay its own proceeding, where the applicant establishes entitlement to such to exercise of the discretionary power of the court in its favor. However, it has been established by case law that a trial judge has no power to grant an application for stay of proceedings where an application for leave to appeal is pending before the Court of Appeal. See the case of Eze versus Okolonji. This decision in Eze Okolonji was followed in the case of Mobile Oil Nigeria versus Ken Energy International and that of Ojo versus INEC. Applying the principle of law enunciated in the case of Okolonji and others, this court does not have the power to entertain an application for stay of proceedings when there is pending before the Court of Appeal an application for leave to appeal against the decision of this court. With the pendency of the application for leave at the Court of Appeal, this court does not have the requisite jurisdiction to hear and determine the claimant's applicant's application for grant of stay of proceeding. This means that their application for stay of proceeding is incompetent and same must be struck out. Accordingly, I hereby struck out the motion on notice seeking for stay of proceedings for being incompetent due to existence or pendency of an application for leave to appeal against the decision of this court before the Court of Appeal. This is the ruling of the court. I make no order as to cost.
As the court pleases.
We are most grateful. It's the same date.
Okay.
Date.
Okay.
Thank you, my lord.
Yes. This case is adjourned to 13th of December 2022 for hearing. Hearing notices to be issued and served on the claimant. Proof of service to be taken in the case file.
As the court pleases. Suit number NICN UY 13 2019 between 1. Lawrence Wakama, 2. Emmanuel Nsudo, 3. Ekpe Akpe, 4. Sunday Dimwa, 5. Sunday Jeremiah, 6. Ekpedeme Dixon, 7. Napoleon Okparadu, and 108 others, and Mobile Producing Nigeria Unlimited. My lord, the parties are all absent.
Appearance.
With profound respect, my lord, my name is Adetayo Talabi. My appearance for the defendant.
Yes, sir. Very well. Yes, sir.
This matter is for ruling. The ruling is ready. This is the ruling of the court. This deal with a notice of preliminary objection brought pursuant to Order 17 Rule 1 and 9, Order 30 Rule 18 Sub Rule 1, and Order 49 Rule 1 Sub Rule 1 of the National Industrial Code Civil Procedure Rules 2017, Section 173 of the Evidence Act 2011, and under the inherent jurisdiction of the court. The notice of preliminary objection is seeking for an order of this honorable court dismissing the suit herein, the suit for being caught by res judicata, the subject matter having already been litigated upon by the respondent against the applicant and decided by competent courts. Further, or alternatively, an order of this honorable court dismissing the suit herein having been commenced by the claimant respondent as an abuse of court process. Further, or alternatively, an order of the honorable court dismissing the suit for not disclosing a reasonable course of action against the applicant. The grounds for this application are as contained on the face of the application. The application is supported by a 27 paragraphs affidavit sworn to by Isio Gene Idibe, an attorney in the law department of the applicant. The learned senior advocate of Nigeria appearing for the dependent relied on the deposition contained in the affidavit in support, and that contained in the 21 paragraphs of further and better affidavit. The learned secretary also adopted the 2 addresses filed along with the notice of preliminary objection and further and better affidavit. 4 issues were formulated for resolutions. I have captured the argument on the 4 issues in the body of the ruling, so I will skip reading them. The counsel for the claimant's respondent filed a counter affidavit and a 21 file a counter affidavit and an address along with the 3rd counter affidavit. A single issue was formulated for resolution. I have captured the argument on the issue formulated in the written address of the claimant applicants. I have captured all the argument of counsel, so I shall go straight to the decision of the court to save time. It is clear from the content of the notice of preliminary objection that there are 3 prayers being sought by the claimants that are being sought by the defendant applicant, and the prayers are in the alternative. The first prayer is for this suit to be dismissed for being res judicata. The second prayer is, which is in the alternative, is praying for dismissal of suit, being abuse of court process, and lastly, last prayer is for dismissal of this suit for not disclosing reasonable course of action. In the written address filed by, along with the notice of preliminary objection, the defendant applicant formulated 4 issues for resolution, while the claimant respondent on their part formulated a sole issue for resolution. The facts that necessitated filing this preliminary objection, as can be gathered from the affidavit evidence before the court, are that the claimant respondent in this suit were among the parties represented in the case that was filed before the Federal High Court, Uyo Division, in suit number FHC/CS/568/04 between Okon Johnson and others versus Mobile Producing Nigeria Unlimited and others. The Federal High Court delivered its decision in the said case on 24th day of April 2006. Being dissatisfied with the said decision of the Federal High Court, the claimant respondent, through their counsel, appealed to the Court of Appeal, Calabar Division. The Court of Appeal, on the 21st day of May 2009, delivered a decision setting aside the judgment of the Federal High Court and declaring the appellants who were plaintiffs at the Federal High Court as employees of the defendant. See Exhibit A attached to the counter affidavit of the claimant's respondent. Being dissatisfied with the decision of the Court of Appeal, the defendant applicant appealed to the Supreme Court. In the decision delivered by the Supreme Court on 20th day of April 2018, the Supreme Court affirmed the decision of the Court of Appeal with Order C3 set aside, with only Order C3 set aside. The claimants, in an attempt to impose the judgment of the Supreme Court, filed a garnishee proceeding at the Federal High Court in suit number FHC/CSMISC 568/04. The defendant judgment debtor filed an application for striking out of the garnishee proceeding and setting aside the order nisi made by the court. The Federal High Court, in its ruling, set aside the order nisi and struck out the garnishee proceedings for lack of jurisdiction. See Exhibit C1I attached to the affidavit, CI1 attached to the affidavit in support, which is the same with Exhibit B attached to the counter affidavit of the claimant's respondent. There has been no appeal against the said ruling. The preliminary objection of the defendant applicant in this suit is for dismissing the claimant's respondent suit on the ground that this suit is called by res judicata and also being an abuse of court process and lack of disclosure of course of action. According to the defendant applicant, the enforcement of the Supreme Court judgment and the monetary claim of the claimant respondent have been determined by the Federal High Court, the Court of Appeal, and the Supreme Court. In the defendant's applicant's view, the claimant respondent are in no stop from litigating the issues that have been determined by the court. In response, the claimant's respondents contended that their action is not caught by res judicata, as the garnishee proceeding at Federal High Court was enforcement of Order D2, which was for 27 persons mentioned in the judgment of the Court of Appeal, which the present claimants respondent are not beneficiaries. On the material claim, the claimant's respondent insisted that the decision of the Federal High Court, Court of Appeal, and that of Supreme Court cannot in response, the claimant's respondent contended that the action is not caught by statute, is not caught by res judicata, as the garnishee proceeding at Federal High Court was for enforcement of Order D3, D2, which was for 27 persons mentioned in the judgment of the Court of Appeal, which is the present claimant's respondent are not beneficiaries. On the monetary claim, the claimant respondents have been determined by the Federal High Court, Court of Appeal, and that of the Supreme Court. Counsel insisted that the claimants are respondents are entitled to file a fresh action to claim their entire right and as declared by the court. The ruling of the Federal High Court in suit number FHC/UY/MISC 568/04 on the objection to the garnishee proceeding delivered on 4th of April 2019 was attached to the affidavit in support of the preliminary objection as Exhibit E1I. The judgment of the Federal High Court in suit number FHC/UY/CSP delivered on 21st day of January 2006, that of the Court of Appeal in appeal number CAC 47/2006 delivered on 21st day of May 2009, and that of September 2000. And that of the Supreme Court in appeal number SC 33/2009 delivered on 18th day of April 2018 were attached to the originating processes filed with the order of court made on 18th day of March 2021. Looking at the said ruling and the three judgments, it is clear to me that the claimant respondents, though not specifically mentioned or named as parties on the garnishee proceedings, they are nevertheless parties in the garnishee proceeding. This is because they were represented. Given the above analysis, I have no doubt in my mind that the parties in the case at hand were also parties in the garnishee proceeding before the Federal High Court and in the substantive suit decided by the Federal High Court and the appeal that followed at the Court of Appeal and at the Supreme Court. The relief sought by the defendant, by the claimant respondent at the Federal High Court were captured in the three judgments mentioned above. I have carefully considered the reliefs and the decisions which the dependent applicant relied in raising the current preliminary objection, which is to be determined, what is to be determined is whether the issues submitted in the present suit are same with the issues determined in the case at Federal High Court, Court of Appeal, and the Supreme Court to constitute res judicata or estoppel. The expression res judicata means a thing adjudicated, a thing judicially acted upon or decided. a thing or matter sued by judgment, it came out of the original expression res judicata. The principle enshrined in res judicata is derived from the maxim nemo debet bis user sin constant curae quod sit pro una, which means, literally translated, means no man ought to be twice vexed. If it is proved to the court that it is for me for one and the same cause. See Oshoboja versus Dada, 2009, 18 Nigerian Criminal Report, Part 1172. Yakubu versus Ajakuta Steel Company Limited, and AO versus Okpe. See also Makun versus Federal University of Technology, Mina. Estoppel parem judicatum postulates that if an action is brought and the merit of the question arising therefrom between the parties be disclosed, and a final judgment of the court competent jurisdiction is handed down over to the parties and the subject matter thereto, any person whatsoever as against the other person is stopped in any subsequent litigation from disputing or questioning such decision on the merit, between whether it be used to be foundation of an action or relied upon as a bar to any claim. See the case of Yoye versus Olubode. See also Arubo versus Ayeleru. See also Dokubo versus Ogoni and Odinigi versus Oyeleke. By the doctrine of res judicata, once a dispute or matter has been finally and judicially pronounced upon or determined by a court of competent jurisdiction, neither parties thereto nor their freebies can subsequently be allowed to relitigate such a matter in court. A judicial decision properly handed down is conclusive until reversed by a superior court, and its veracity is not open to challenge, nor can it be contradicted. In other words, the rule of estoppel parem judicatum requires that where a final decision is given by a court of competent jurisdiction, the parties thereto cannot be heard to contradict that decision in any subsequent litigation between them respecting the same subject matter. As a plea, the decision operates as a bar to subsequent litigation, and as evidence, it is conclusive between the parties to it. Once it is found that the question is caught by estoppel parem judicata, the matter that there the matter lies. The term derives is posed from public policy, which says there must be an end to litigation. There are two types of estoppel. One, cause of action estoppel, which occurs when a cause of action is merged in the judgment. That is transit in res judicatum. On this principle of law, once it appears that the same cause of action was held to lie or not to lie in a final judgment between the same parties who are litigating it in the same capacity, that is the end of the matter. The second estoppel is issue estoppel, which occurs where an issue had earlier on been adjudicated upon by a court of competent jurisdiction, and the same issue comes incidentally in question in any subsequent proceeding between the parties. The rule is that once one or more issues have been raised in a cause or matter and distinctly determined or resolved between the same parties in a court of competent jurisdiction, then a general rule neither party is allowed to relitigate or those decided issues all over again in another action between same parties on the same issues. It is settled law that for a plea of estoppel parem judicatum, be it cause of action estoppel or issue estoppel, to succeed, the parties relying on it must establish that the parties, their previous are same, that the race or subject matter of litigation in the two cases are the same, that the claim in the case cause of action estoppel or the issue estoppel in dispute in case issue estoppel is the same, that the decision relied upon to support the plea is valid, that the court that gave the decision relied upon is a court of competent jurisdiction. Unless all these constituent elements or requirements of the doctrine are fully established, the plea cannot be sustained. They must be satisfied conjunctively, and failure of any of them is fatal to the action, to the plea of res judicata. See the cases of Omiale versus Macaulay, Daniel Taylor Transport Enterprises Nigeria Company versus Busari, Daudu versus Attorney General Lagos State, Dokolo versus Rewani Dokolo. The court, in determining whether the issue, the subject matter of the two actions and the parties are same, the court is allowed the court is entitled to look at the originating process in the case being considered and the entire case and this judgment. See the case of Agbasi versus Obi. It is clear to me that Exhibit EI1, the ruling on Ganeshi proceeding at the Federal High Court on monetary claim, was a final decision, and that it was delivered by a court of competent jurisdiction, and neither is it in dispute that the subject matter that led to both suit in the judgment of the Supreme Court in suit number SC 33/2009 between Mobile Producer Unlimited and Okon Johnson and others. It is also clear to me that the present claimants respondent are parties in the appeal and at the Supreme Court. In the Ganeshi proceeding, the claimant respondent were represented by the judgment creditors who sued the defendant respondent. In this suit, a representative capacity, whether the claimant respondent are not beneficiaries does not matter, because as at the time they sued to impose the judgment of the Supreme Court, there is no impediment that has been shown that it deprives that deprives them of including the enforcement of their said decision, the said decision as it affects them, which they are now seeking to enforce through the present action. It is settled law that the term parties for the purpose of estoppel include not only those named on the record, but also those represented. See Omoto Show versus Oloribe, see Osuride versus Ajomogu, see Akpam versus Uni, see Ekenia versus Impakura, see also Omiale versus Macaulay. It is clear that the present claimants are the direct beneficiaries of the judgment of the Supreme Court delivered on 20th day of April 2018, which was subject of Ganeshi proceedings at Federal High Court and had I quite agree with the submissions of counsel for the defendant applicant that the law is clear that a plea applies not only to points upon which the court was actually required by the parties to form an opinion and pronounce a judgment, but to every point which properly belong to the subject matter of litigation and which the parties exercising reasonable diligence might have brought forward. Thus, it is irrelevant that the respondent may or may not have specifically referred to any existing collective agreement at the time of formulating his issues. See Yakubu versus Ajakuta Steel Rolling Company Limited, Supra. It is settled that styling, restyling, or misstyling parties to an action should not prevent a court from examining the proceeding in issue and determining whether parties in the present suit are the same parties to the part in an earlier suit, and thus caught by doctrine of res judicata. Since the present claimants respondents were represented, they are parties also to the said garnishee proceedings. This means that the said decision cannot be reopened by a court of coordinate jurisdiction. The assumed jurisdiction to impose the said judgment of the Supreme Court, which the Federal High Court has decided on, engaged in such voyage will amount to sitting on appeal on the decision of the Federal High Court. For the defense of res judicata to succeed, there must be sameness of parties, but this does not mean that all the parties in the previous suit must be made parties in the latter suit. It is sufficient where there are several parties in the previous suit that those of the parties who are necessary parties to be issues applies the principles of sameness of parties. I have come to the conclusion that the parties in the two suits are same parties within the definition of parties for the purpose of res judicata. On sameness of issues, the facts relied upon by the claimant respondent in suit number FHC UYCS 568 OPO or Con Johnson and others versus Mobile Producing to sustain the monetary claim as can be garnered from the judgment of the Federal High Court, Court of Appeal, and Supreme Court, where that the claimant least paid staff, which is also the basis of the claimant's monetary claim in the present action. Part of issues presented for determination before the Federal High Court in the case where monetary claim of the claimants, see Relief 5A. The failure of the claimant to comply with the law on the proof of special damages lead to the appeal court refusing to grant the said relief due to lack of proof. The Court of Appeal decision was affirmed by the Supreme Court. This means that the parties are barred from raising or making same claim before another court in respect of the relief that was denied them previously by the court. It is right law that once it is made clear that the same question was substantially in issue in the two suits, the precise form in which either suit is brought, or the fact that the claimant's respondent in the same case were defendant in the other is immaterial. Estoppel subsists between the parties. See Pale versus Ola Otafo. See also Oyera Ba versus Olaufa. See also Onyeduchi versus INEC. Additionally, looking at the facts relied in the two suits, it cannot be contested that the same evidence was required to prove the claim in both suits. The court stated that one of the criteria of identifying the two suits in considering a plea of res judicata is the inquiry whether the same evidence would support both. See Madukolu in Kendele. See also Koka versus Olukoba. See also Njoku versus Dikibo. What the claimant respondent in this suit have done in the present case was to attempt to use packet of using personal capacity to pursue claims that were refused them by the Court of Appeal and affirmed by the Supreme Court. The doctrine of res judicata or estoppel is recognizes that as a part of the principle that society must discourage prolongation of litigation. The doctrine has been developed in such a way that a party to civil proceeding is not allowed to make an assertion against the other party. The two suits in question bring to mind admonition given by the courts that in considering the conditions for applicability of estoppel, they must be alive to the antics of parties who are desirous of beating the applicability of the doctrine by adopting different subterfuge, including in beclouding the name of the parties and the issues in the letter suit. See answer versus Intuk. The warning was echoed by Toby. From all I have been saying above, it is my conclusion that the decision in the Garnishee proceeding at the Federal High Court delivered on 4th of April 2019, as contained in Exhibit EI1, operate to bar the claimants responding in this suit from imposing judgment of the Supreme Court, since they were parties to the Garnishee proceeding and have not utilized the opportunity to impose their rights. Therefore, they cannot now wake up from their slumber to seek to impose the judgment that the Federal High Court has decided upon. No party is allowed in law to impose his right in piecemeal, as the claimant want to do in this case. The claimant respondent have admitted piecemeal enforcement when in their addresses they have stated and instituted an action in the Federal High Court in Okon Johnson's and others versus Mobile Producing Unlimited was enforcement of part of the Supreme Court judgment for 27 persons specifically mentioned in Order D2 in the judgment of the Court of Appeal, which was equally affirmed by the Supreme Court, which is not declaratory but executory judgment. The 27 persons were not part of the present suit. This submission has gone to show that the claimant respondent were engaged in piecemeal enforcement of the judgment of the Supreme Court, which is a law defricate. On the monetary claim, the position of the claimant is that the Court of Appeal judgment, which was affirmed by the Supreme Court, it was declared that the claimant's respondent are employees of the dependent. Based on the declaration, the dependent applicant is expected to recognize the claimants as its employee forthwith and make proper arrangement to absorb him into the system in compliance with the Supreme Court judgment. The claimant respondent were it is the position of the claimant that the implication of the Supreme Court judgment is that the dependent should absorb them, claimants, as his employee and pay them their appropriate benefit as his employees. According to the counsel, this does not translate to claim for monetary benefit by the court as against what the dependent applicant is asserting. It is further argued that based on the Supreme Court judgment, the claimants respondent are entitled to full benefit as enjoyed by the other employees, having been so declared. Where employment is determined, the rights and privileges denied employee can be imposed, and this is the claim before this court, says counsel for the claimant respondent. It is clear to me that the submissions of counsel regarding monetary claim did not take into cognizance the holding of the Supreme Court in the judgment of 20th day of April 2018. The court stated thus: the only observation I wish to make is that the appellant has imparted right to transfer the case to 15th respondent to anywhere, to any area of its operation, because they are compliance. not being one cannot eat his cake and have it, not being supernumerary police officers, they cannot wish to be governed by the Police Act. That's the order of the lower court on page 5959 of the record of the appeal, particularly order number C3, only is hereby set aside. The appellant can transfer his staff as it deems necessary. Apart from this, I affirm all the orders made by the court below in this matter. The two issues 2 and 3 are accordingly resolved against the appellant. Having resolved the 3 issues against the appellant bearing the few corrections I have made in the judgment of the lower court, I hold that there is no merit in this appeal. I affirm the judgment of the lower court and orders made therein as amended. I shall make no order as to cost. It is clear from the above quoted portion of the Supreme Court judgment that it only refused the relief on transfer, which it held that the defendant has right to transfer its staff to anywhere they have operation. All other orders of the Court of Appeal were affirmed by the Supreme Court. It is pertinent to note that the only order of the Court of Appeal affirmed is the one that refuses to grant relief 5A payment of the sum of 50,635,000 for each of the 833 number of members of plaintiffs as mobile, PES dependent employee or staff as contained in the PES dependent January 2004 nominal roll of the members of the plaintiffs and aforesaid or aforementioned 27 members of plaintiff listed in relief 4B above and exhibit N2 and N4, including second and third plaintiffs, making an overall total of 860 number of members of plaintiffs, making a total of 43,546,000 for 43,546,831,000. For all the aforesaid overall total number of members of staff of plaintiffs being their due financial entitlements or benefit or emoluments as employee or staff or workers of the PES dependent for 8 years from 1997 to 2004, inclusive, have been so employed by the PES dependent and or having been entered into having contract of employment or contract of service with the PES dependent, and a breakdown of their said financial entitlement or benefits or emoluments as aforesaid and as payment by the PES dependent per year to each of the list of its staff. The Court of Appeal unequivocally refused to grant the claim for salaries, emolument, benefit, and entitlement on the ground that the claimants have failed to prove entitlement to the claims because they have lumped up the claim without particularization. See pages 34 to 39 of the Court of Appeal judgment. By the relate two of the statement of facts, the claimant seeking for an order of court directing the defendant to pay claimant, respondent, unpaid salaries and arrears of severance benefit packages due to the claimants in line with the conditions of service of employee in the collective bargaining agreement between the defendant and his employee. The amount being claimed by the claimant respondent is from the inception of their employment until the ceremonial termination of their employment. There is no doubt that the claim of the claimant respondent as contained in their relief to include the claim which the Court of Appeal had refused to grant to the claimant's respondent due to failure to prove said claim. In the circumstances, to allow the claimant respondent to include the claim which had been refused by the Court of Appeal will amount to this court entertaining appeal from the decision of the Court of Appeal, which was affirmed by the Supreme Court. The claimant's respondent having litigated some part of the claim put forward before this court are stopped from relitigating the claim already determined by the Court of Appeal and affirmed by the Supreme Court. Or relief 3, which is for payment of pension, there is no evidence to show that pension claim had been litigated. In the circumstances, this claim will proceed to trial. From all I have been saying above, the dependent applicant's notice of preliminary objection succeed in fact For avoidance of doubt, the order of the court is as follows. Relief 1, for having been litigated at Federal High Court, is hereby dismissed. Relief 2, the part of the claim which covers the period of 1997 to 2004, having been litigated and refused by the Court of Appeal and affirmed by the Supreme Court, is hereby refused. The claimant cannot also base his claim on a collective bargaining agreement entered into by the defendant and Pengassan, as the claimants have not established their membership. Of Pengassan. The claimants respondent are hereby ordered to resume 14 days from the date of this ruling to amend their originating processes to be in line with the decision of the court. The defendant should, upon receipt of the claimant's respondent's amended process, also within 14 days, file consequential amendment, if any. Relief 3, having not been litigated, relief is to proceed to trial. This is the ruling of the court. I make no order as to cost.
We are most grateful, my lord.
Yes.
My lord, can we have the same date, December 13?
It's all right. This case is adjourned to 13th of December 2022 for hearing. Hearing notices to be issued and served on the claimant. Yes.
We are most grateful, my lord.
Registrar, next case. Registrar.
The summary of this.
Yes, Mr. Talabi.
My lord,
I've come to the end.
My lord, that's all for.
it's very tiny.
Okay. You are free. You can decide to exit. You can exit the meeting as you wish.
My lord, we have another matter before you. The motion
Yes.
ex parte.
Yes.
Maybe you use their piece.
Yes.
Okay, my lord. Suit number NICN CA 40-2022 between Professor Frank Nwokedi I. Mora and 1, University of Calabar. 2, Professor Florence Obi, Vice Chancellor. 3, Edidem Henshaw, Acting Head of Estate Unit, University of Calabar. My lord, the parties are absent.
Okay.
Why? Take your piece. Announce your appearance. Can you hear him?
No.
Can you?
No,
Fine.
we can't.
Appearance.
If it pleases court,
Yes.
my name is,
You can announce your appearance while sitting.
as court pleases. My name is Paul Eko.
Paul Eko.
Then my lord, Eko is spelled E-K-O.
Yes.
My lord,
Appearing
appearing for the claimant applicant,
Yes.
holding the brief of Oyong Esquire. My lord, Oyong is O-Y-O-N-G.
Yes.
My lord, we have a motion ex parte before you.
Yes. Yes.
My lord, the motion ex parte is brought pursuant to Order 17, Rule
Yes.
1. Lord, sub rule 1 and
Counsel.
order 17. My Lord,
Counsel, what
my
is the urgency? What is the urgency of this application?
my Lord, the urgency is that the respondents are using their men to push the Professor Mokedi, Frank Mokedi, out of the quarters, the Unica staff quarters, for BQ4 at the Unica premises. And then while this matter is pending before you,
No,
we are
that-
coming
that is-
for an order
that-
to restrain.
that is not correct. I have read all your processes. According to you, you said the university on the 7th of February 2022 served the claimant with a request to vacate a property that is occupying, which belongs to the university. 7th of February 2022. So when you count how many months from February to date, March, April, May, June, July, August,
For
September.
about 8 months.
So how can you say that it's urgent? If it is urgent, you would have filed it in February when they serve you with the letter.
My Lord, the action is just commencing. That's why we filed it, sir. The torrential.
This is the evidence I have before me. This is evidence. It is your own evidence. You have exhibited
My Lord,
the
that's
letter.
true.
The letter. You have exhibited the letter.
Yes,
And
my
even-
Lord.
Even in his in the affidavit in support, he said
Yes, sir.
when the letter was delivered, his daughter called him. He said his daughter called him.
Yes, sir.
Before subsequently they went, and he says a strange wife also called him concerning the same threat to throw him out of the property. So if that is true, that they have served you with this notice since February, it means there is no urgency. There is no urgency. When you read the UTB, Universal Trust Bank versus Dolmet, Supreme Court was very clear that for an interim injunction to be granted, the applicant must be very vigilant. He must be very, very prompt. He should not delay. So having delayed for 7 or 8 months, you cannot convince me to say that there is urgency in this matter. So I will order you to serve the defendant so that
My Lord,
you say
we serve the defendant with a motion on notice, sir, which will file the same.
we give you date. We give you date for hearing. With the service on them, they will not do anything. They will not disturb your client. And if they do, then you take appropriate action against them. Let us give them chance to come.
As God please, sir.
And registrar.
It's calling.
What date is 18th of October?
Hello, my lord.
Check your diary. Which day is 18th of October?
18th of October. Okay, my lord. Oh, keep it for me, please. Okay, my lord, 18th October is a Tuesday.
Do we have cases on that day?
Yes, my lord, we do. We have one adoption, 1, 2, 3, 4, 5, 6, 7 hearings, my lord.
Okay, so I will adjourn the matter to that date so that we can hear the motion on notice. Serve them with hearing notice. Serve the defendant with hearing notice against 18th of October.
Yes, my lord. Yes, my lord. My lord, what of the motion on notice? They were not served. The defendants were not served.
Hey, you serve them with the motion on notice. Serve them. Serve them
Okay,
with
my lord.
all the processes they have filed.
Yes, my lord.
Serve them with all the processes they have filed.
Yes, my lord.
Let me write my ruling.
Yes, my lord.
Having listened to submissions of counsel, I am of the view that this is an appropriate case in which the defendant should be put on notice. In the circumstances, I hereby ordered that all the processes filed in this suit, including the motion on notice for interlocutory injunction, should be served on the defendants.
As court pleases.
Therefore, this case is hereby adjourned to 18th of October 2022 for hearing of the motion on notice for interlocutory injunction. I also hereby ordered that no of the parties in this suit should do anything that will in any way affect the outcome of the hearing of the motion on notice for interlocutory injunction.
As court pleases.
So this registrar, you can draft the order. I say you can
Yes,
draft the order so that you can serve it along with the processes and serve it on them. This case stand adjourned to 10th or to 18th of October 2022 for hearing of the motion on notice for interlocutory injunction.
As the court pleases.
Any other matter?
My lord, that's all.
Okay, thank you very much, counsel.
Thank you, my lord.
We have come to the end of today's virtual sitting. The court will rise. The administrator, you can end the sitting. Thank you very much, counsel.
Thank you, my lord.
Okay.